Yes, thank you, Judge. Andrew Mickus on behalf of Ms. Owens, P76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right, did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that that figure is going to be 0 because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plead. Okay, all right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was,
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
Before we even get into the plea discussion, let's set the stage, because this case is about to go completely off the rails. What should have been a routine plea hearing turns into a masterclass in how not to answer a judge's questions. On paper, this looks simple: 2 nearly identical retail theft cases, most of the merchandise recovered, and an agreement already worked out between counsel. But courtroom reality doesn't care about what's worked out if the defendant can't articulate responsibility. Watch closely as this unfolds, because the tension here isn't about evidence, it's about honesty. The judge is giving multiple opportunities to resolve this cleanly, and every time, the defendant manages to step on her own case. This is one of those hearings where you can almost feel the judge's patience thinning minute by minute. And the real twist? The more chances she's given, the worse it.
All right,
Yes,
I can't
ma'am.
accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
No,
if
you're not guilty. Miss Owens, you've been through
I
this
just-
before. You've got
Yeah,
a ton of
I'm-
larceny convictions, right?
I'm
This isn't your
confused
first
on
rodeo.
which-
And ma'am, you're not required to enter a plea of guilty. But if you think you're
No.
gonna sit here, I'm talking. If you think you're gonna sit here and tell me that you didn't do anything wrong and think I'm gonna accept your plea, you're sadly mistaken. I'm happy to have
I'm
a jury
confused.
trial. I like nothing more than a
I'm-
jury trial. You either want to accept a plea or you don't, and you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item.
Anytime you hear the words mutually agreeable resolution, you expect smooth sailing from there. But seasoned courtroom watchers know this is where things can quietly derail. The attorney lays out the agreement clearly: 1 plea, 1 dismissal, restitution likely 0, and the ability to pay if necessary. This is textbook damage control. But notice what's already happening beneath the surface. The judge is laying the groundwork for a factual basis. A guilty plea isn't just a word you say, it's an admission supported by facts. And that's where things start to wobble. This is the calm before the storm, because the court isn't just listening for guilty, it's listening for why. If you can't explain your conduct in plain language, the court can't accept the plea. This moment matters more.
I tried to pay for the item.
All
but
right,
it doesn't.
so that's a not guilty plea. So, okay, we're gonna just go ahead and set these both for
But the
jury
second
trial.
one, I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan
No.
$250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the
that
first
scanner.
case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
Your Honor, I'm guilty.
We're going to jury trial.
Your
I'll
Honor,
set
if
a
I,
jury trial date and we'll see you on that date.
There was
Your
a-
Honor, if I may have an opportunity to briefly in a breakout room with my
No,
client.
I've had enough of your client, quite frankly, and the games
Ma'am.
she likes to play. She's lucky I
This
didn't
isn't
revoke
a
her
game.
bond the first time, and now she
Ma'am.
wants to play with whether or not she's responsible of this or not. And no, I'm not
not.
comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your
I
jury
didn't
trial
say
date in the
that.
mail. We're all
I
set,
did not
ma'am.
say
I'll
that.
see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Mr. Mikos, I'm sorry, I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial. All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mickus, P 76268 on behalf of Ms. Owens.
Ms. Owens, tell me your name.
J.C. Owens.
Ms. Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Ms. Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal items.
Wheels start coming off. The judge walks step by step through the elements: location, store, merchandise, intent. These are not trick questions. This is the judge giving the defendant every possible chance to lock in the plea. And yet, instead of clarity, we get hesitation, hedging, and uncertainty. This is dangerous territory for any defendant. When you plead guilty but start distancing yourself from intent, you're asking the court to do the impossible: accept responsibility without responsibility. The judge is being patient, but you can hear the concern. A plea requires a clear admission of intent, not confusion or backpedaling. Every vague answer here increases the risk that the deal collapses entirely.
I think, I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff.
Toiletries or-
Toiletries, yeah.
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout.
Yes, Your Honor.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm gonna accept the plea as knowing and voluntarily given, the case ending in 230962. That case will be dismissed per the plea. Meet with the probation department for a pre-sentence investigation. You're gonna get notice of that in the mail.
This moment is pivotal. When a defendant says, "I don't know how to answer that," the court hears one thing: avoidance. Whether intentional or not, this sounds like someone trying to plead guilty without admitting guilt. The problem is that criminal law doesn't work that way. The judge isn't accusing, she's clarifying. Did you place items in your cart you didn't intend to pay for? That's the heart of larceny. And the longer this drags out, the harder it becomes for the judge to justify accepting the plea. You can practically see the defense attorney trying to salvage the situation, but there's only so much lawyering that can overcome contradictory answers from the client or the turning point. The judge makes it crystal clear: honesty is non-negotiable. Courts don't accept half confessions, technical excuses, or emotional gymnastics. Either the defendant accepts responsibility, or the case goes to trial, period. What's especially important here is the judge referencing prior convictions. That's not intimidation, that's context. The court is signaling that this behavior isn't new, and patience has limits. When the judge says she's perfectly happy to hold a jury trial, that's not a bluff, it's a warning shot. This is the court saying, you don't get infinite chances to play.
Okay.
And you're gonna meet with them and, I'm sorry, Mr. Mikos?
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're gonna meet with the probation department, Ms. Owens, and they're gonna contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah,
Okay, all right, well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date, because I don't know how backed up they are on their PSIs.
I understand.
So,
Would it,
so it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
okay, we're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Claiming that $250 worth of merchandise wasn't scanned by accident is where credibility really collapses. Judges hear accidents all the time, but accidents have boundaries. Multiple items, significant value, and a pattern of behavior erase the benefit of the doubt. This exchange exposes the core issue: the defendant wants the benefit of a plea without the burden of accountability. The judge's frustration here is entirely procedural, not personal. She's trying to protect the integrity of the court record. And at this point, the plea agreement is effectively dead, revived only if the defendant finally tells the truth. Just like that, clarity. One sentence accomplishes what 10 minutes of evasion could not. This is exactly what the judge was asking for from the beginning. No excuses. No ambiguity. Just intent. Notice how the tone of the courtroom immediately changes. Once the defendant owns the conduct, everything